Dear students, I welcome you to yet another lecture on corporate law. The topic for today's lecture is shares. In this lecture, we shall be discussing the meaning of shares. We shall also be discussing the statutory requirements of allotment. We shall also discuss call on shares. First and foremost, we shall be discussing the meaning of shares. The capital of a company seldom comprises of a single unit. In fact, it comprises of numerous indivisible units. These units are of a specific amount. Therefore, when a person purchases such a unit or several units, he purchases a certain defined percentage of the share capital of the company. In this case, he becomes one of the many shareholders of that company. Thus, we can say that a share is the interest of the shareholders in a company, and the capital of the company is divided into certain units of fixed amounts. These units are known as shares. Let us take an example. The total capital of a company is 5 lakh rupees, which is divided into 50,000 shares of rupees 10 each. Each unit of rupees 10 is called a share. In this case, there are 50,000 units, that is 50,000 shares of rupees 10 each, and the capital is 5 lakh rupees. The Companies Act has provided an extremely vague and ambiguous definition of a share. According to Section 2, Clause 84 of the Companies Act 2013, a share is a share in the share capital of the company, and it includes stock as well. It would be pertinent to quote the definition of shares given by Justice Farewell in Boland Trustees versus Steel Brothers Limited. He said, and I quote, "A share is the interest of a shareholder in the company measured by a sum of money for the purposes of liability in the first place and of interest in the second, but also consisting of a series of mutual covenants entered into by all the shareholders." Unquote. In the case of Commissioner of Income Tax versus Standard Vacuum Oil Company Limited, shares were defined as an interest of money value and made up of diverse rights and liabilities specified under the Articles of Association. Dear students, we shall now discuss the nature of shares. The shares of a member in a company are movable property as per Section 44 of the Companies Act 2013, and they are transferable in the manner provided under the articles of the company. Even though the share is a movable property, it cannot be moved as a common commodity. A share is a commodity brought into existence by the legislature. Hence, a share is incorporeal in nature and has a bundle of rights and obligations. This was the observation of the court in Vishwanath versus East India Distilleries. Stock is a collection of fully paid shares that are consolidated and divided for the purpose of convenient holding into different parts. A stock denotes that the company has recognized the fact of complete payment of shares and can be assigned in fragments. Dear students, let us now come to the rights which usually attach to shares. These are: number 1, the right to attend general meetings and vote. Typically, shares carry 1 vote each at general meetings, but there may be non-voting shares or shares with multiple votes. Some shares may carry the right to vote only in particular circumstances where the company has different classes of shares. The other right is to a share of the company's profits. The distribution of profits is paid by means of a dividend of a certain amount paid on each share. A dividend may be paid only if the company has made profits and to the extent that it decides to distribute them. If the company so provides in its articles, different dividends may be paid on different classes of shares. The third right is to a final distribution on winding up. If the company is wound up and all the creditors are paid, the remaining assets are available for division among the members. This may be done in 2 stages. The first stage is return of capital. The second is distribution of surplus capital. Some shares may be given a priority as to one or both of these. The fourth right that attaches to a share is that the company may be run lawfully, that is, in accordance with the Companies Act. the general law, and the company's constitution. In most circumstances, only the members of the company will have the right to sue the company to make it act lawfully, and even they may be restricted in their ability to sue under the common law rule in Foss versus Harbottle. Now, dear students, we discuss allotment of shares. The offers for shares of a company are made on an application form supplied by the company. When such application is accepted, it amounts to allotment. What is termed as allotment is neither more nor less than acceptance by the company of the offer to take shares. Broadly speaking, it is an appropriation by the directors of shares to a particular person. Dear students, we now come to the procedure which has to be followed in case of allotment of shares. The first step is that a public company has to file a prospectus or a statement in lieu of prospectus inviting offers for the purchase of shares in the company. Number 2, when the public applies for shares of the company in the prescribed format, the company can issue the price of the share to be paid in full along with an application, or it can be made payable in installments as share application money. The amount payable as application money has to be at least 5% of the nominal value of the shares. Number 3, no allotment of shares has to be made unless the minimum subscription as given in the prospectus has been subscribed for. This is provided in Section 39 of the Companies Act 2013. The minimum subscription has to be stated in the prospectus. The company has to receive the minimum subscription amount within 30 days of the issue of the prospectus, and if this is not done, then the company has to return the amount within the specified time. Number 4, a return of allotment has to be filed by the company with the registrar making allotment of securities. It is important to remember that there is a penalty for non-compliance with the provisions of the Act. The penalty is ₹1,000 for each day during which the default continues, or ₹1 lakh, whichever is less. Further, Section 40 of the Act provides that every company intending to offer shares or debentures to the public by way of prospectus shall, before making such offer, make an application to one or more recognized stock exchange or exchanges and obtain permission for the securities to be dealt with in such stock exchange or exchanges. Where a prospectus states that an application under subsection 1 of section 40 has been made, such prospectus shall also state the name or names of stock exchange in which the securities shall be dealt with. After the allotment, the directors can call upon the shareholders to pay the amount due on the shares in a manner as mentioned in the prospectus. The articles of the company usually contain provisions regarding this. Private placement. According to Section 42 of the Companies Act 2013, a company may make a private placement through issue of offer letters for private placement. Provisions of Section 42 become applicable to such placement. The offer of securities or invitation to subscribe for securities can be made to a number of persons but not exceeding 50 or such higher number as may be prescribed. This number is not to include qualified institutional buyers and employees of the company being offered securities under a scheme of employee stock option as per the provisions of Section 62, subsection 1, subclause B. This can be done in one financial year and on such conditions as may be prescribed, which is to include the form and manner of private placement. The first explanation to subsection 2 provides that an offer of private placement to more than the prescribed number is deemed to be an offer to the public and is governed by the provisions of section 23 to 41 relating to public issues. This will be so whether the company intends to go in for enlistment or not in or outside India. The second explanation to subsection 2 states that for the purposes of this subsection, the expression used in it will have the meaning that a qualified institutional buyer means one as defined in the Securities and Exchange Board of India Issue of Capital and Disclosure Requirements Regulations 2009 as amended from time to time. According to Section 42, Clause 3, no fresh offer or invitation is to be made by the company unless allotments made under any earlier offer have been completed or that offer has been withdrawn or abandoned. All monies payable towards subscription have to be paid through cheque or demand draft or other banking channels and not cash. As per Section 42, Clause 5, securities have to be allotted within 60 days of the receipt of application money, failing which the application money would have to be refunded within 15 days or else 12% interest would become chargeable. The money received on application is to be kept in a separate bank account in a scheduled bank and is to be utilized only for adjustment against allotment of securities or refund as given under Section 42, Clause 6. Offers can be made only to persons whose names are recorded by the company prior to the offer. They should receive the offer by name. A complete record of such offers has to be kept by the company in a prescribed manner. A complete information about an offer has to be filed with the registrar within a period of 30 days of circulation of the relevant private placement offer letter. As given under Section 42, Clause 7, a company offering securities under this section is not to release any public advertisements or utilize any media, marketing, distribution channels or agents to inform the public about the offer. Section 48, Clause 8 explains that after making allotments, the company shall file with the registrar a return of allotment in the prescribed form by the company, which consists of a complete list of all the security holders along with their full names, addresses, number of securities allotted and also any other information. Consequences in case of default. Section 42, Clause 10 provides an explanation stating that any contravention of the section would make the company, its promoters and directors liable to a penalty which may extend to the amount involved in the offer or 2 crore rupees, whichever is higher. The company shall then be in a position to refund the money to the subscribers within a specified time frame of 30 days of the order imposing the penalty. Dear students, we shall now discuss the general principles which govern the allotment of shares. The first general principle is that allotment of shares has to be made by a proper authority. Allotment is generally made by a resolution passed by the Board of Directors. This duty cannot be delegated by the directors. It is necessary that the board pass a valid resolution of allotment in a valid meeting, as was held in the case of Holmes District Consolidated Gold Mines RE. In Portuguese Consolidated Copper Mines case, it was held that an allotment by a board irregularly constituted may be ratified by a regular board. The second requirement is that the allotment has to be made within reasonable time. Allotment is basically made within a reasonable or a specified period of time, otherwise the application shall lapse. The specified time frame of 6 months between application and allotment was held to be not reasonable in the case of Ramsgate Victoria Hotel Company versus Montefiore. The third principle is that allotment shall be communicated. It is essential that there must be communication of the allotment to the applicant. Posting of a properly addressed and stamped letter of allotment is considered as a sufficient communication even if the letter were to be delayed or lost, as was held in the case of Household Fire and Carriage Accident Insurance Company Limited versus Grant. The fourth principle is that allotment must be absolute and unconditional. As per the terms and conditions of the application, the allotment must be absolute and unconditional. Thus, in Ramanbai versus Ghasi Ram, where a person applied for 400 shares on the condition that he would be appointed cashier of a new branch of the company, the Bombay High Court held that he was not bound by any allotment unless he was so appointment. The fifth principle is that allotment can only be made via application. A valid allotment cannot be made on an oral request. A person should agree in writing to become a member of a company. Number 6. Allotment cannot be made in contravention of any other law. Hence, any shares that are allotted on an application of a minor, such allotment is void. Dear students, we now come to the meaning and definition of call. A call may be defined as a demand made by the company on its shareholders to pay a part or a whole of the unpaid balance within a specified time. Lord Linde says that the expression call denotes both the demand for money and also the sum demanded. The following points should be noted in this context so that we can really understand what a call means. The first point is, call can be made at any time during the lifetime of the company or during the course of winding up. During the lifetime of a company, the call should be made by the board of directors, and during the course of winding up, it should be made by the liquidator. Number 2. Each shareholder is obliged to pay the amount of call as and when the call is made. But this liability arises only when the call is made and not before. As soon as the call is made, the call amount shall become a debt due from the shareholders to the company. Number 4. If a shareholder fails to pay the call amount, the company can enforce payment of the amount together with interest or can forfeit the shares. Number 5. A call is different from other payments made by a shareholder. The amounts paid on application and allotment are not calls. Similarly, if a company requires the shareholders to pay the entire amount either on application or on allotment, it is not a call under the Companies Act. Dear students, we now come to the legal provisions relating to calls. The statutory provision relating to the making of calls can be summed up as, number 1, the first thing that we have to remember is the power to make calls is generally in the nature of a trust, and so it can be exercised bona fide and for the benefit of the company. It should not be made for private ends. It means the directors or the liquidator can make the call only when there is a bona fide need for funds. The second thing that we have to remember is that calls should be made on a uniform basis on all the shares falling under the same class. If a call is made only on some shareholders of the same class but not on others, or a greater amount is demanded from some shareholders and a lesser amount from others of the same class, the call is not valid. Third, the call should be made strictly in accordance with the provisions of the Articles of Association. If this is not done, the call will be invalid. A share certificate is a written document signed on behalf of a company that serves as a legal proof of ownership of the number of shares indicated. A share certificate is also referred to as a stock certificate. When companies issue shares in the market, shareholders who buy in are issued a share certificate. The share certificate basically acts as a receipt for the purchase and ownership of shares in the company. The document certifies registered ownership of shares from a particular date. Key information on share certificate includes, number 1, the certificate number, company name and registration number, shareholder name and address, number of shares owned, class of shares, issue date of shares, amount paid or treated as paid on the shares. Now, dear students, what is the importance of share certificate? Share certificates serve as evidence of ownership of shares. If we compare them to the purchase of a property, a certificate serves as a certificate of title. Hence, it is essential that all the information on the certificate is correct. Further, when a shareholder dies, the share certificate is what evidences their ownership of shares and allows for the transfer of shares. Indeed, an application will need to be made to the company to change the name of the share certificate. Historically, share certificates were required for proof of entitlement to dividends. Each time a certificate was presented, the receipt for the payment of dividends was endorsed on the back. This way, all records of dividend payments were attached to the document. If a share certificate is lost, stolen or destroyed, the shares are not lost. Instead, a company can reissue a certificate. In such an instance, the shareholder will need to write to the company and provide a statement. This statement will need to declare that the share certificate has been lost and not sold or otherwise disposed of. Dear students, this was all with regard to today's lecture on shares. Hope you have been able to enjoy the lecture and understand the concepts fully. Thank you and stay blessed.